San Diego Gas and Electric went to the U.S. Supreme Court last year after its argument had been repeatedly rejected by state courts and energy regulators since 2012. The utility argues that the deadly 2007 wildfires, which officials have connected to it, were out of its control, and it shouldn't be on the hook to pay for it, says Maria Severson, the attorney representing customers on this case.
San Diego Gas and Electric. There you had a situation where there's a devastating fire. They had higher costs than just their operations because they had to pay out all these claims from the fire that it caused. But the utility commission found, after hearings and public hearings, it's like a trial, they found that no, they did not meet the prudent manager standard. They were not prudently managing their operations. They weren't clearing the brush. So who has to pay for that? The innocent customers or the shareholders?
This week, she says the Supreme Court announced it had sided with state regulators who say the utility wasn't acting responsibly.
But the state of the law now is there's a prudent management standard. The Supreme Court of the United States decided it wasn't going to upset that.
And that's a good thing, she says, because the standard holds utilities accountable for safety. But she says state legislators went around that when they swiftly passed a $21 billion wildfire bill this summer.
Essentially, it's going to put customers on the hook. It's trying to break that and move away from that prudent management standard.
The bailout, as she calls it, has customers paying for future wildfires, and Pacific Gas and Electric's bankruptcy from last year's devastating Camp Fire, considered to be the worst in state history. Shalina Chatlani, KPBS News.